welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the latest developments at the London Court of International Arbitration, known the world over as the LCIA, with Kevin Nash, who's been the LCIA's Director General since November 2024. I'm JP Duffy. I'm an international arbitration partner at Bracewell, based in New York, that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitral rules, including those of the LCIA. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I previously practiced. We're fortunate today to have Kevin Nash as our guest, whom I've known for several years and who I had as a podcast guest around this time last year when we were both at different organizations. Kevin is a Canadian lawyer by training and became the LCIA's Director General in November of 2024, as I mentioned, having moved into that role from a senior role at another administrator. As the LCIA's Director General, Kevin functions as the CEO and oversees the LCIA's day-to-day operations, in addition to acting as the interface between the institution and its board and the court. Kevin is also the face of the LCIA on the global stage. So as you can tell, we have a great guest today that can offer a wealth of knowledge about the LCIA, which just had a banner year that Kevin's going to tell us more about. Before we hear from Kevin, though, I just want to give some more information about the LCIA to set the stage for our discussion. The LCIA is the oldest arbitral institution in the world. It started out in 1892 as the City of London Chamber of Arbitration and was comprised of members from the City of London Corporation and the London Chamber of Commerce. The LCIA's original purpose, which it still serves today, was to offer an expeditious alternative to court for resolving commercial disputes. In 1903, the organization's name changed to the London Court of Arbitration, and in 1981, it changed its name again to its present one, the London Court of International Arbitration, to reflect the international nature of its caseload. The LCIA was incorporated as a private company in 1986 and remains a private, independent, not-for-profit administrator today. So with that, let's hear more about the LCIA directly from Kevin, because as I say, they had a pretty incredible year, and Kevin's got a lot to share on that front. So welcome, Kevin. We're grateful to have you here today, and it's great to hear from you again.
Thanks, JP. It's great to be talking to you in these new roles and looking forward to the discussion today.
Good. Kevin, let's begin with talking about your transition. When did you formally transition into the role of the LCIA's Director General?
JP, a bit of an error on my side, because the announcement was in mid-November, but I actually started in mid-January. So I'm right about 6 months into the role. Obviously, there was a long runway and then trying to clear everything really up until 31 December in Singapore.
Oh, that's good. Well, good. Well, you seem like you've been in the role now forever, given your prominence. So we'll forgive everyone for getting the dates initially wrong. How have you found that transition to London from Singapore?
Well, I think the most difficult thing was going from the city-state of Singapore to London. You're going to two very different cities, but they also happen to be the two best jurisdictions for arbitration. In terms of the transition to LCIA, to me, it's been really energizing, maybe even a little bit humbling, because when you step into such an old, vaunted institution, it really means that you're inheriting a legacy where there's real institutional gravitas, but also the fact that expectations are high. So when you're coming from SIC and Singapore, there is this expectation that you are going to bring that blue chip case management. What I've found really striking about coming to London is just the depth of talent here. The legal system is really unmatched in terms of depth and diversity. And for me, I've really enjoyed engaging with the city, the bar, and LCIA's global users. The role is a bit different. It's more public facing. I was already quite public facing in Singapore, but I'm sort of taking a more macro approach in terms of the case management. So overall, it has really been a good transition, and the support of the community has been really inspiring.
Well, that's great to hear, and somewhat unsurprising given the role that the LCIA plays in the international arbitration community. What would you say is the nicest surprise that you've had in your new role?
The currency of an institution is really the case management. And I think that when you're at an institution, you're really trying to achieve perfection. So at LCIA, we have an active caseload of around 1,000 cases. And for me, I've genuinely been impressed by the quality of the LCIA secretariat and the dedication. And for users, for lawyers, I think it's quite easy to take for granted how efficiently a case is managed. But when you see the engine up close, the judgment, the responsiveness, the care that goes into every decision, it's really quite special. And it's almost institutional craftsmanship that is based on more than 130 years of experience.
Wow, it is certainly a long-standing institution that's got an excellent reputation around the globe. And with that, what would you say the biggest challenge has been?
I suppose for me, when you have this historic institution, the biggest challenge is probably balancing this tradition of excellence with innovation for arbitration in 2025 and beyond. The LCIA has a reputation rightly earned for being principled, consistent, and fiercely independent. But at the same time, we're in a period where users expect speed, transparency, the integration of tech, and responsiveness to a bunch of new sectors, crypto, ESG, and digital infrastructure. So the challenge really is, how do you modernize without compromising what makes LCIA special? So that means, I suppose, for me to try to carefully calibrate procedural updates, rethink certain aspects of the rules, and work with the board, court, and secretariat to evolve the offerings while at the same time protecting those core values of the institution. And for me personally, it's always a challenge to step into a highly visible role where an institution is always admired. I've been making the joke that anything that has went wrong before, I'm avoiding being blamed, and I'm also taking credit for all the good work that has been done. But you also don't want to overstep, and at the same time, you want to leave. So I'm kind of navigating that tension, especially relatively early on, but it's really a good kind of pressure.
Yeah, that's a good problem to have. So let's talk about that a bit, because the LCIA just released its 2024 annual casework report, and the results of that were extremely impressive. Now, obviously, as you mentioned, you joined formally in January of this year, but let's talk about those results and what they show to you. Let's start with how many new arbitrations the LCI registered in 2024, because I think you said the overall caseload is about 1,000 active. What was new in 2024?
So you've got 318 arbitrations that are administered under the LCIA rules. Then you have a certain number of arbitrations under the UNCITRAL rules. Also, LCIA is very strong in fund holding. But JP, one thing that I really like about LCIA is, because when you have a blue chip institution like that, we're not deciding whether we're good or bad year on year based on the numbers. So I don't have to start extrapolating right now in July to determine what the 2025 caseload is going to be. I think what goes without saying is that LCIA administers some of the highest value and most consequential cases in the world. So while the numbers are good, and I really like the jurisdictional spread, 95% international parties from 101 jurisdictions just in 2024 alone, but it really is about the quality of the casework and the case management, and that's what gives us credibility. So I try not to look, having been doing this for so long, at the 2024 report as a scorecard. I think it shows a signal that LCIA is really well positioned to keep growing, modernizing, and to lead on the quality of our offerings.
Well, that's really nice. And that's certainly the advantage of being a long-standing, well-known institution, is that you don't really have anything you have to prove. It's just more confirmation of the exceptionalism that's already there.
Yeah.
But let's dig down on that for a bit, because I think some of the stats to me jumped out as ones that are very intriguing and that show a really interesting trend. Now, you mentioned about 95% of the cases are international. How many of those international cases did not involve an English party?
So you've got 75% of the cases don't involve an English party, which to me is a lot different than what I thought the LCIA was before I joined. It is just so much more international than I think sometimes you get the sense of, because you have the London in the name LCIA. So this is a properly international institution.
Right. So it's 75% of those cases do not involve an English party. Those are parties from totally different jurisdictions that have no real connection to England, I guess, other than maybe perhaps English law or something.
Exactly. It could be an American party and a Norwegian party and international parties on both sides.
Got it. And I think you said there were 101 different jurisdictions that those parties came from. Is that right?
Yeah, in a single year just for 2024. And that global footprint is really exciting. Paula Hodges was the president of the LCIA court for 6 years, and she just stepped down in May. Maxie Shearer is now the president of the LCIA court. So I was trying to commemorate all of Paula's good work. And so I went back and I was assembling the statistics for the past 6 years. In the past 6 years, parties from 161 jurisdictions, 99 different governing laws, 70 different seats of arbitration. Like, this really is one of the most global caseloads that we have in all of institutional arbitration.
That is really impressive. And I think that does come, as a bit of a surprise to some people, given that, LCI has obviously always been extremely international. But I think having London in the name does imply sometimes that there's an English connection. So that extreme breadth of jurisdictions and parties is really impressive. Now, let's just dig into that for a moment. What, obviously, aside from UK parties, what were the top 5 nationalities of users in 2024?
So you've got Kenyan parties as the leading international user, followed by US parties, Swiss parties, Emirati, and then Russian parties. I think the continued presence of Russian parties, particularly in some very high value disputes, shows how the general license, where LCIA is able to administer cases involving sanctioned parties, it shows that this is really working, and also shows the long history of Russian parties choosing to resolve their disputes in London.
Now, let me just pick up on that for a moment. The LCIA has an exception for sanctions and Russian parties. Is that correct?
Yeah, exactly right.
Okay, so there's no issue then with the LCIA administering a case involving Russian parties that might, I'm not suggesting this is the case, but that might be sanctioned or subject to other sanctions elsewhere.
Well, I suppose that sanctions always bring in a level of complexity, but at least the payment to the institution and the payment to the arbitrators, this can be made under the general license if you have a sanctioned party or a party that somewhere within the beneficial ownership may be sanctioned. So being able to facilitate and expedite those payments has really helped. You have stories out there in the arbitration ether about payments taking 6 months or 12 months and everything is delayed, or an institution not even being able to accept a payment at all. So that's what the general license solves. Of course, there remains issues of legal costs, potentially, or jurisdictional issues, all the rest that come with sanctions. But in terms of those payments, that can be made under the general license. And it actually is working so well that I find it quite unremarkable, because we have a lot of cases involving sanctioned parties and the payments are able to come in expeditiously.
And that takes a huge issue off the table, and is certainly something that I know other institutions have struggled with. Now, you mentioned Kenyan parties being the top user in 2024. When I read the report, it looked to me like 17% of the cases overall came from Africa, which was the second highest region in 2024 behind Western Europe. Did I read that correctly?
Yeah, absolutely right. And what is even more striking is that you have more African parties than British parties.
Wow.
So the LCIA is administering more cases involving African parties than British parties. When I saw that and I was using my abacus and lining up the figures, I mean, this is a really important development, and it's part of a broader story about the internationalization of arbitration and the role that African parties are playing, and the confidence and sophistication and their ability to drive the dispute resolution choices.
Now, are most of those parties from Africa coming from Anglophone Africa? Do you have a sense of that, or is that reflected in the numbers?
Yeah, I mean, it is mostly that. I mean, Africa is such a compelling region. In addition to Kenya, we also have a significant amount of parties from Nigeria, South Africa, and Ghana, but it does tend to come along sort of the English speaking jurisdictions rather than French speaking.
Okay, so jurisdictions that may also have a tradition in the English common law.
Exactly right.
Okay.
But of course, as you know, as you go along in arbitration, you realize that common law and civil law divide can start to be a bit blurry. So we also have had functionally domestic arbitrations where you have an African civil law party on both sides where they've selected LCIA rules, LCIA administration, and London, for instance, as a seat of arbitration.
Interesting. Well, and certainly, given the prominence of English law internationally and international cross-border contracts, that's not surprising either.
Yeah.
Now, what do you see? You were saying it's a compelling story. What do you see as driving that increase in cases from Africa? Like, what's the story there that's causing that?
Yeah, that's a good question. I mean, I think overall, and not confined to the LCIA, that we're seeing more sophisticated contracts coming out of East Africa in particular, whether that's infrastructure, telecoms, energy. And these contracts increasingly contain international arbitration clauses. Of course, sometimes there will be an impact on the numbers by clusters of related cases. So in 2024, there were separate groups of matters, each involving multiple arbitrations between overlapping parties. So that contributed to the spike in numbers. But beyond those clusters of cases, the broader trend for African parties is upward. So this is part of a wider pattern of African parties. And I think importantly, being more active as claimants and not just respondents. I think that's really how you see and monitor the development of a jurisdiction when these parties start to be the clause makers and the moving parties in arbitrations.
Absolutely. I 100% agree. And that's a huge distinction to draw. It's not hard to say there's been an increase in parties when those parties are all respondents.
Yeah.
When they are also the claimants, that's a true indication that there's a real maturation of the jurisdiction.
Yeah.
Now, one thing I noticed too is there was a slight decrease in the MENA region cases in 2024. And it looked to me like it was down to 11% overall from 16% in 2023. And interestingly enough to me, just given my interest in the region, it looked like there was about a threefold drop in cases from Saudi.
Yeah.
What did you attribute that to?
Well, I mean, I think that in the spirit of institutional comedy, I think I have to give credit to the development of very good institutions in MENA. So you have the SCCA starting to become a very solid institution, DIAC, Arbitrate, AD. But I would also note the Queen Mary University of London White and Case survey, where LCIA is the second most preferred institution in MENA. And actually, if you look around the globe from that Queen Mary survey, which really drives some of the narrative in arbitration, that LCIA is the second most preferred institution in every region, except for the US, where it's third behind ICC, AAA, ICDR, and then in Asia, where LCIA does not rank. So there's always been a strong presence for LCIA in MENA, and the parties are very comfortable with LCIA from that region. And so we'll continue to be very active there, and we continue to see strong interest from parties in MENA.
No, absolutely. And I mean, again, the continued use of English law in MENA-related contracts will always ensure that LCIA has an extremely significant role to play in that region.
You know, JP, if I could just react to that, I mean, we're very lucky. I mean, the percentage of international contracts that use English law, and often LCIA will end up piggybacking on those English law contracts as the administering institution, and the same with London as a seat of arbitration. So we're at a significant advantage because you have this very long history and the prevalence of using English law as the law governing the substance of the dispute.
Yeah, well, it's a great advantage to piggyback off of. So
yeah.
Good one to keep in mind. Well, let's shift gears a bit then and just talk about some of the industries from which those 2024 cases were coming. What were the top 5 industries that international cases came from for the LCIA in 2024?
We're looking at transport and commodities, banking and finance, energy and resources, construction and infrastructure, and then technology. I mean, we're transporting commodities in particular. I mean, there is that very strong tradition in London, and we used to get a lot of these disputes in Singapore as well. And I used to have sort of a private joke that I would say about international arbitration in Singapore, particularly for commercial disputes, that everything was going on a boat at some point. And so whether it was Kalamazoo, steam coal, things were going on a vote. So London is very strong for this. But I think what I like to see is some of the emerging sectors and seeing technology starting to feature more prominently, because you do have this tradition of transport and commodities, those high value banking and finance disputes, energy and resources, construction, of course. But it's fun to see some of the newer sectors standing out. And it's almost like you have to try to sort of be everything to all things. So those very traditional sectors, you want to make sure that you're preserving the user confidence in those sectors. And then you also want to see if you can advertise and show the advantages of the LCIA for some of the newer sectors.
No, it is interesting to see some of those sector percentages. And, notably to me, it looked like transport and commodities declined by about 7% in 2024. So that was an interesting development as well. What do you attribute that to?
Oh, I mean, sometimes it can be just the way that you're classifying disputes, and disputes can be in the margins. So whether or not this is functionally transport and commodities dispute, or whether this somehow sort of bleeds into construction and infrastructure dispute or a corporate dispute. I mean, there's a variety of ways that they can be categorized. I mean, what we're really talking about for transport and commodities, we're talking about these sort of classic contracts for the sale and carriage of goods, charter party, shipping, freight forwarding, storage, and then the related financing arrangements, which again can move it over to a different category.
Got it. Well, that makes sense as well. Well, now with that, what are some of the industries that you'd like to see LCIA increasing in or increasing its visibility in going forward?
I mean, it's really some of those new sectors, and that's where I think that we're very lucky to have Maxi Shearer as the president of the LCIA court, because she's one of the leading voices that we have on tech, digital infrastructure, AI disputes. So, and it's not, I think when we're looking at the mandate of the institution, it's not just to promote the LCIA for these type of disputes. And when you're talking about an increased presence for tech disputes, it's really showing the advantages of arbitration generally. And sort of the deeper that I go into this profession, the more I just want to be a promoter of institutional arbitration, where you're showing the advantages of arbitration over other forms of ADR, whether that's litigation, mediation, adjudication. So certainly looking at tech disputes, crypto and blockchain. I think esports and digital media is an interesting area. We're pretty good on life sciences and healthcare. And a lot of times when you're looking at sort of the suitability of these disputes, you're really looking at some of those economic channels. And I think one of the most obvious ones for life sciences and healthcare, that is going to be Northeast United States, India, and probably both sides on that contract are going to be very comfortable with the LCIA.
Yeah, I would agree with that. I do obviously a lot in the life sciences healthcare sector, and I think LCIA is a really natural fit for a lot of those, and particularly in that paradigm of transaction that you're describing between, say, Northeast US and as well as Eastern Canada and India. It's just a very natural fit. Yeah. It's an easy one to get clients to agree to.
Yeah, absolutely. And I know of your expertise because more than one institution, we've been looking at you as an arbitrator for these types of disputes. So, I mean, it's a good area, but there's so many to focus on. Like now I'm realizing that I didn't talk about the possibility of green energy disputes, ESG. These are really moving from a conference topic to an actuality. And that's what makes international arbitration fun, and being at an institution like the LCIA that was really at the center of everything.
Yeah, absolutely. And we do a lot of that type of work at Bracewell, and it is truly going to be, I think, an explosive area for international arbitration going forward. Because I agree. I mean, it's a wave of the future, and I see it as well. It's not just something that people are talking about at conferences anymore.
Yeah.
Well, let's shift gears for a moment then. I just want to talk about one thing in the report that jumped out at me, which is, and it was really impressive, it was the EDI results in arbitrator appointments that the LCIA achieved. And there are a lot of different aspects of that. So let's just examine them a bit. For instance, one of the things I saw, despite 78% of the cases in 2024 being governed by English law, it looked like about 45% of the arbitrators appointed in those cases were not British. And about 50% of those appointments were made by the LCIA court. So what is sort of the profile of an arbitrator getting appointed in that instance, in a case like that?
I could almost do this as a parlor trick of the different factors that you're going to run through when you make an appointment. So, say in a case that's governed by English law, you would typically want an arbitrator that's qualified in English law, but not necessarily. You could have someone that is qualified in another jurisdiction from the common law tradition, but you could also have a civil law qualified arbitrator. The institutions are really doing the diligence on these appointments. And I'll be honest, I think 2 minutes into the job, what I wanted to see more than anything was who is LCIA appointing. And this is actually true, that I immediately went through all of the appointments, and LCIA has really been at the front of the curve in terms of the diversity of appointments. I think the EDI guidelines are revolutionary in it, and really it was part of the reason why I joined LCIA, was seeing how they are conducting themselves as the real thought leaders in arbitration. But what I think is important to always say is that the starting point on arbitrator appointments is to make sure that you're appointing the best arbitrator. But when you have such a diverse user base, that this will sometimes be an arbitrator with diverse characteristics. Basically, when you're looking at those 101 jurisdictions across a range of sectors and quantum, probably from 5,000 pounds to a couple billion or 5 billion pounds, you want your arbitrators to match that very diverse user base. But of course, subject to the governing law and seat of arbitration, as you said, because you've got many of those cases being governed by English law.
No, I think you're going about it the exact right way. Now, one of the things that jumped out at me about this too, and you touched upon this, it looked like additionally about 45% of the arbitrators that the court appointed were women. 72% of the arbitrators appointed were only appointed once in the same calendar year, and then 14% of the court's appointments were first-time appointments. So it looks like an awful lot of thought is obviously being put into this. So one question I had looking at those statistics in the aggregate was, how many of those appointments are then younger arbitrators, like people that would be on the younger end of the age spectrum versus more senior, established, well-known appointed names?
First we have to establish what we mean by young, because young in arbitration, I think, is very different than young in life. That young in arbitration number keeps getting higher. So whether that's 40 or 50, so it's all relative. But having served as an appointing authority in Singapore, and I've made hundreds of direct appointments, advised on thousands of actual appointments. Sometimes I would say, when I mean young, I actually mean young, and sometimes an age that has a 2 at the beginning. So those are going to be relatively rare. But I think what's important for an institution is that you have to develop the pool of arbitrators, and you cannot do it overnight. So this is a product of work that the LCIA has been doing for decades in terms of putting arbitrators in the right place. You cannot just start appointing diverse arbitrators. That you have to have been building up these diverse arbitrators for many years. And it was actually important for me, JP, when you mentioned that 14% of the court's appointments were first-time appointments. These are first-time LCIA appointments. So that could mean an arbitrator that had sat dozens of times, but it happens to be a first-time LCIA appointment. And what you really want to avoid as an institution is this thought or reputation that there is a small cadre of arbitrators that are being appointed again and again by the institution. And that's why you have the very compelling number of 72% of the arbitrators only having been appointed once in the calendar year. But I can tell you as Director General, if someone had already been appointed once or even twice, and that person was still the best arbitrator for the job, absolutely, I would be recommending their appointment again.
I think that gives users an awful lot of comfort, because it is really important to balance those two things, right? You want to see a large group and a large pool of arbitrators. You also want to know that you're getting the right person for the job. So it's really good to see that you're putting that much thought into it and balancing those two, what can be competing interests, although not necessarily every time. Well, those are all really impressive results. And now we're pretty much halfway through 2025. And I know you're not using these things as a scorecard, but certainly it's a natural thing to look ahead and say, what do we want to do for the remainder of 2025? Where do we want to see ourselves in 2026? So let me just ask you, in the time that we have left, what's the initiative that you've taken for 2025 about which you're most proud?
Yeah, so I'm past that 100 days as a CEO where you get to just listen and watch. And now I think there's so much momentum with the LCIA, and people are talking about the LCIA, this new generation of the LCIA so much is that now I think that the market is expecting deliverables. And it goes without saying that the case management has to remain perfect. And the feedback on that case management is very good. And I think having done so much of that case management, I can help the already talented secretariat. So to a certain degree, some of the changes that I'm proud of and that I really want to focus on for the latter half of 2025 is a lot of these internal processes, because the domain knowledge that we have from practice, other institutions, I think really is unmatched. I want to invest in our digital case management capabilities, looking at AI. I think that I'm meeting with third-party vendors a couple times every week. And how can we incorporate these kind of advanced tools into this very traditional institution? I've been talking about looking at whether a rules revision is warranted. So we might have something on that. And then expanding our outreach and training. JP, I'm not sure if you noticed the new additions to the LCIA court. You've got many court members that come from other institutions, and really some of those thought leaders that have been very active in outreach and training and helping to develop arbitration in new jurisdictions.
No, I did notice that, and it's a really impressive group. And I think, it signals to the market very clearly that the LCIA is preserving those traditions that you talked about earlier, but seeking to innovate and stay at the forefront of what's important globally as well. So all excellent to see. Well, now I say this, we were talking a little bit about age. I say this as someone who paced out of the Y&I groups, depending on which one, probably 5 to 10 years ago now. So you're obviously on the younger end of the spectrum. So you have the opportunity to be in this role for a while, and to really put your stamp on the LCIA. So let me just ask where you'd like to see, where would you like to see the LCIA in, say, 5 years?
The director generals have stayed for a long time, and maybe, I'm a little bit on the younger end. I think Adrian Winstanley was there for 17 years. Maybe Jackie was there for 10 years. So that is a very long runway. But at the same time, I'm really trying to sort of bring that hunger that we have coming from Asia. And I don't want to wait. And I often find myself feeling a bit impatient. And I think maybe sort of the biggest bucket that we could use to describe what I want to do is to make sure that the LCIA is the global standard setter in arbitration. I don't want to be comparing statistics. I want to be comparing impact. So what are we introducing? How are we making arbitration better? How do we shape dispute resolution generally? So that's a very broad KPI. But if we could continue to lead on issues like arbitrator ethics, the EDI guidelines, be a leader on digital processes and the use of AI in case management, I think that would be a success. I also want to continue to develop arbitration and really be a flag bearer for international arbitration. So 101 jurisdictions in 2024. I would like to see that number go up. I would like to be participating in training so that we can start shifting those claimant versus respondent ledgers in some of these emerging jurisdictions. But I suppose if I had to pick one very broad theme of what we want to be, is that global standard setter in institutional arbitration and international arbitration.
Well, certainly you're well positioned to do that, because the LCI name alone gives you the opportunity to do that. And you've obviously personally got the skill set to accomplish that. So I think we are all watching with rapt attention to see you accomplish that, because I'm quite certain you will.
And JP, I'm sure that we will see you as counsel and arbitrator in LCIA arbitrations. I mean, one of my big priorities is really getting over to the States. As a Canadian, it comes very naturally to me. So we definitely want to deepen our engagement there. And I imagine that we'll be seeing you and Bracewell in LCIA arbitrations.
Oh, well, that's great. Well, thank you. And certainly our London office is already doing that, and so is our New York office and elsewhere. So great to hear, and we're always happy to help support you in any way we can. That's a good point, too, to say that we would love to have you back again in the future to talk about some more of these issues, because I think we've barely scratched the surface of what we could discuss, because there is just so much going on at the LCIA and so many things that you're leading that are really of interest to the audience. So I think we're going to have you back at some point in 2026 to hear more about this.
Absolutely. Anytime, and always a pleasure.
Great. Well, with that concludes our discussion of the LCIA. I want to thank Kevin Nash, our guest, for his time and invaluable insights. And I want to thank you, the audience, for listening. You should feel free to reach out about today's podcast with any questions you might have to either Bracewell or to Kevin. There's an email address, arbitrationacumen@bracewell.com, to which you can email questions, or you can probably find Kevin's contact details out there on the internet. And we look forward to having you tune in for future episodes in the Arbitration Acumen series. So thank you, Kevin, and great to hear from you.
Thank you.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.